Councilors, Manager Bush has just totally emasculated the process of appointing a hearing examiner. Because the code does say that the hearing examiner must be based, or the selection must be based solely on qualifications. Now he's making that the sole criteria. So if he selects anybody that has reasonable qualifications, then you must approve it. And I say that's an absurd ruling, or an absurd reading of that. There's nothing needs to be done until June, so you're getting railroaded on this again. I believe, and I will offer to do some research to show what is done in other states. There's no necessity to do it tonight. I believe that the Manager Bush is just taking the decision out of your hands. The way he framed his last comment was, now it's up to the commission, is he qualified? That's not the deal. You're appointing a hearing examiner, and while the rule does say, or the code does say in Title II, that it has to be based on qualifications, I think you need to look more deeply and not accept that off-the-cuff comment by the city manager. It's another move. It's a strange one. It's a strange interpretation of Title II. And I ask that 3 people say, no, give me 2 weeks to submit some research to the council. I'm offended by the definition, by the way the manager is trying to control this selection. Thank you very much.
Mayor, if I may. So, despite what has been asserted, the city council, or I'm sorry, the city staff have looked at RFPs from other council manager forms of government, and they have gone through this RFP process for the hearings examiner. They have done precisely what we were talking about. It's my understanding at the last meeting, someone had made reference to Linwood's practice. Linwood is a strong mayor city, and in Linwood, everybody at their director level and on up, including their hearings examiner, goes before a panel before the city council. So we're talking about 2 completely separate processes here, and we're talking about, from a staff perspective, implementing something that is traditionally what is done among other city council manager forms of government, at least in our region that we've looked at, and nothing that we're proposing is unusual about this. And I question the hard determination that appears to be unsupported in terms of timing. We don't know when the timing is going to be. It's going to be 21 days after the decision has been made on the merits of the building permit. Whenever that happens, we have 21 days and we need to be ready to get those appeals in order, get them before a hearings examiner, get them scheduled, have any pre-conference meetings that we need to have with the applicants and all of the appellants. There is a process involved to that. So we are trying to be diligent in our time and in council's time, and we are trying to work through this as best as we can, given the time limitations that we have. And as Charlie mentioned a little bit earlier, regardless of what people want to believe, there are some limitations on who will actually come to the peninsula for hearings examiner services. So that is something else that we have to contend with too. And when we issue the RFP, we want to make sure that we have enough time in there to reach out to perhaps some other people who might not be as inclined to travel to the peninsula if we can't get enough people to respond to our RFP. So that's what I would have to say in response to the comments.
If I may actually weigh as well on Bob. Hold on. Bob, no, please don't override me. Mr. Mayor, I would actually like to give our city manager the courtesy of finishing what he was talking about. I would like him to give us, the council, his presentation, and then I would like to weigh in as far as what I know and give the other councilors up here their time. But I think our city manager maybe had some closing thoughts about what he's going to present with us, and I'd like to discuss it between us.
Yeah, that was essentially it. I was just kind of framing the question before council as I see it.
Okay. If I may, Mr. Mayor, I have a few comments of my own on this hearing examiner. First, 3 points. One is I understand Charlie's go out and selecting a hearing examiner to some degree because we do have an appeal about the MAP process to date. However, how I see that scenario playing out is, even if we had a city manager today and he was to yield a decision, his decision would be appealed to either side. I mean, just assume the decision either, that decision is gonna get appealed. And according to, you know, our Sequim Municipal Code 20.01.03, the chart that shows the, you know, the flow chart, the hearing examiner's decision is appealable to the council. So I'm actually in favor of saying not at this time for the hearing examiner, because, you know, I anticipate the council being the appeal authority as far as the MAT appeal. Anyway, so that's one thing. Let me get the other two and I'll open it up. The second thing is going back to last fall, when I know the discussion was brought up to having a hearing examiner in the first place. And I think we're getting a little top heavy in just how we have our government here. We have 7 counselors, we have a city manager, assistant city manager, attorney, and we have a planning commission. I think it would be nice to discuss, you know, okay, the role of the planning commission. If we, you know, we have a lot of decision makers, I think we need to streamline that first. It's particularly like, okay, the hearing examiner versus the planning commission. I would like to have that time and that discussion before entertaining the hiring of the hearing examiner. And last thing, before I yield here, right now with all of the changes between, with Charlie stepping down in April, with us promoting Sharice as a new interim city manager, with Jennifer stepping down, we have a lot of vacancies to fill right now. And I think that the hearing examiner is a pretty significant position, and I think it would behoove us to wait on this position, which goes back to my number one as far as the MAC clinic. I think we as a council are the appeal authority, so thank you. That's it.
I understand for an A2 decision is appealed to the city council unless it appoints a hearing examiner. Isn't that correct?
So, let me see if I can, do you mind pulling that up? So this is where, if you remember last fall, where we were going back and we were cleaning up the code, because those used to say Board of Adjustment rather than hearings examiner, even though we had delegated all of the Board of Adjustment duties to a hearings examiner. There is one portion in the bottom, I believe, of the A2 code where it talks about hearings examiner versus city council. And it is one of those areas where we need to do some cleanup on that. I'm pulling it up here.
They need to clean up if you don't want it to be the city council.
Well, so this is what it says. If you look at, we have all of these wonderful little footnotes in our table, and if you look at it on its face, it does suggest that it goes to the city council. However, if you look at the little footnotes in there, type A2 decision to city council. Open record hearing, oh, wait, I'm sorry. So the applications that are currently on appeal right now are A1 decisions because they were appealing the process. Those are A1 decisions. Okay, so that one is the final decision body made by staff. And the hearings examiner is the appeal authority for the A1 decision. So,
This is A2.
no, actually, what the appeal that we are dealing with right now are A1 appeals. Those appeals are stayed pending a decision on the merits, which will be an A2 decision. That's something that we're also going to need to work out, because our code says also under 20, I think it's 2001, is it 040, where appeals on the procedural matter will be heard at the same time as the decision on the merits. So for purposes of the A1 process that we did, which is the determination of it being an A2 process, that is what is being appealed. They're saying that we're using the wrong process. That's an A1 decision that goes to the hearings examiner. So if we are gonna have to maneuver through this because of the type A2 position when we go to a hearing on the merits, but as we've talked about before, the council is, it has some very significant appearance of fairness issues. So, but we can discuss that another day.
Right, I guess I'm a little confused.
Mhm.
You're saying that the issue is whether it should be A2 or C2, which is an A1 decision.
Correct, yes. And that A1 decision is the one that has been appealed by 3 parties.
All right, I was talking about the appeal of the, assuming it is A2, of the, whether or not the building, the permit should be granted to the M&T claim.
Well, unfortunately to our code, it does look like that is the case. So, as I said, we've got some conversations to be had with the council between now and then, but the fact of the matter is, for the A1 process, the A1 decision that has been appealed by 3 appellants, it goes to the hearings examiner, and we need to hire a hearings
So the
examiner to
hearing
do that.
examiner would be to decide whether it should be A2 or C2. That's what-
Correct,
Is the hearing examiner's, his decision is appealable as well, correct?
yes.
So after him, it would come to the council.
After him, it would go to Superior Court.
You're bypassing the city council,
I am not, the code is.
but. Well, so, do you have this here?
I'm looking at it.
So, both A1 and A2 at the bottom line in appeal authority, it says under A1, hearing examiner, city council.
Correct.
And under A2, it says city council. As far
Correct.
as final, or as far as appeal authority. So, and you're saying that where it's not.
So if you look at A1, where it says hearings examiner, and there's a small footnote C, it says, appeal authority for building and other construction permits, sign permits, and boundary line permits. Subsequent appeals on these permits go to Clallam County Superior Court. So the A1 process is an administrative determination. And because it involves a permit, there wouldn't be a process decision, but for the fact that there is a building permit application, it goes to the hearings examiner. There are very few times in which there would be a standalone decision for the appeal authority to be the council on an A1 decision, if ever. And I know that Ted and Barry have talked about this before, and about how it's somewhat circular.
I really don't have much of an issue on A1 decision.
If I can just touch on a broader subject, since we're already there, might as well talk about it. Well, we have some disagreements with, the charts, and we've had some disagreements with sometimes 1 or 2 sentences, what it means. You're gonna stick with your guns, I'm gonna stick with mine. And, I think on a broader spectrum, as far as, appearance of fairness, we'll both, but I assume, yes, in last May, when the story broke about the mat, since we're talking about the mat clinic, I told everyone within earshot that I had concerns with it as a person, and these were my concerns why. And I stuck with my personal convictions on why this is a bad idea, so I've campaigned on that. And so for me, I've been upfront and honest about my concerns about this, and my concerns are my own. Sometimes those concerns align with other groups, sometimes their reasons and my reasons aren't the same. But as far as what I see from the other side, those are concerns from the staff to me. What I've seen from me as a citizen, now me as a council, is the drift to try to exclude the council from any part of decision making. And it's to me, that's pretty obvious that that's trying to exclude us from the decision making process. So you see what I'm saying? I see where you're coming from with your concerns about me, but do you see where I'm coming from my concerns about?
To be clear, it is not about any one of you, right? Everyone, because the appearance of fairness is not just about your personal belief, it's about the interactions that you have with the public on this. Everyone is tainted tainted in that sense, regardless of whether you personally support or personally oppose the clinic. It's the number and the multitude of contacts and conversations that have swayed or created a bias one way or the other. It has nothing to do with whether or not you oppose it on a personal level. I would be saying the same thing to you if you were coming up to me on a daily basis telling me that you were a proponent of it. The appearance of fairness doctrine is for an unbiased, objective, neutral person, and no one sitting up here on this dais can say with a straight face that they are objective and neutral because of all of the stuff that everybody has gone through for the past 9 months. It's not a judgment. It is not disparaging your personal beliefs or anyone's personal beliefs up here. That is just the law. When the council chooses to sit in a quasi-judicial manner, it is expected to act like a judge. And it's no different than if you had a speeding ticket before one of our local judges and you found out that the law enforcement officer who gave you the ticket was up there chatting up your judge about, man, I catch this Troy, speeding all the time. Make sure you talk to him and get him on this speeding ticket. It's fundamental fairness. And so it doesn't matter one way or the other. You are expected to sit in the role of judges, and you're expected to be objective, and you're expected to be unbiased, which is why I say that every one of you has appearance of fairness issues, because you've all been touched by this time and time and time and time again. So even though, just to be clear, the appearance of fairness doctrine is what tries to get council out of some of these decisions, not staff. This is existing code. And so it has been marked as an area for cleanup because of all of these types of things. But that's not something that we are trying to do other than to protect you and to protect the city entity. So, Ted?
First, I think we have to make a sharp distinction between bias and appearance of fairness. If you're biased, either for or against something, you're permanently disqualified. There is no way you could possibly hear. If you're subject to appearance of fairness, that isn't automatically disqualifying because of the doctrine of necessity. If every single member of the city council has an appearance of fairness issue, we can come back in and make it an issue. Not only that, but we save money because it doesn't matter what we decide, it's going to get appealed. I guarantee you it's going to get appealed to Superior Court. And that way we can at least save a hearing examiner fee.
I have a question. With our choices of hearing examiner, do they have to come out of the risk pool of attorneys?
Mr. Olbricks is not in the risk pool of attorneys as far as I know.
Thank you.
It would be inappropriate if he were, so.
Incidentally, I do want to make a quick comment on Mr. Ulbrich. I think if we're going to have one, I don't think we could possibly do a better job. He is an excellent hearing examiner. My only question is whether we need a hearing examiner.
Are we required by law to appoint one?
In this instance, because they are appealing an A1 decision, yes, you are. You're required by our law to have that. Whether or not we would need to have one for the hearing on the merits, like I said, I think that's probably going to be a topic for future conversations.
Mr. Mayor, pardon me, and I respect, Christine, I know you are an attorney, but I think sometimes, because I personally feel pretty confident in my reading skills, and I do read law. I do read RCW. I can read our Sequim Municipal Code and feel very confident with what it says. So with your question, Mr. Mayor, as far as to our city attorney, is this law that we have to appoint a hearing examiner? I'm going to say, actually, in your response, Christina, you said yes. Like that's not right. In that spirit, I think from my seat, I could use assistance from maybe Bob Bilo taking the podium again and giving us a calm assessment of his reading of the code and what it does and doesn't say. So, Mr. Mayor, put it back to you.
Would the other councilors like to weigh in on that? Councilor Denise, Councilor Smith?
How about you?
Councilor Denise? So it brings us to a point. Councilor Farrell, are you still with us?
I am.
Fantastic. Would you be willing to weigh in on what you've heard so far?
Well, I'm just kind of listening. The way it's progressing, I think that the more we hear it, the better we be.